Inside the Republican AZ Central newsroom, I'm Richard Rellis here with columnist Bob Robb. This is one where, like, the column does a lot of heavy lifting because this is a complicated issue. So let's try to draw people slowly into what gets deep in the weeds. But like you're talking about, I guess it's hard to call it the deep state, but there is an administrative state that you argue just has a lot of power that we don't think about, and particularly conservative lawmakers don't think about.
Here at the state, at the national level, conservatives are complaining about the administrative state all the time. And the administrative state refers to regulatory agencies that exercise legislative, executive, and judicial powers without any really oversight by the real legislature, the real executive, or the real judiciary. Here in Arizona, we have vested state regulatory agencies with vast powers of enforcement, with the same flaw that conservatives are fond of excoriating at the federal level. And we just sort of blithely, even though we've got a conservative legislature, we just blithely let it continue.
Now, Ducey has talked about the agencies being bullies, but it's more in the issue of licensing, which has been an issue that has been favorable, at least in Arizona, Goldwater Institute and some of those, Institute for Justice. This issue, though, you say has not gotten favor of how these agency decisions can be appealed or rectified somehow.
The way the process works in Arizona is the agency decides that there's been a violation of a rule or a regulation and issues what amounts to a complaint. You then, if you're the recipient of this, you have the right to ask for a hearing before an independent administrative law judge, someone who's not connected with the agency. That sounds like it's fair. However, the agency director, either the director or a board of commission, if that's what leads the agency, can completely ignore what the administrative law judge has opined and make whatever decision he or she or the group wants.
Right, so that supposedly independent decision just becomes an advisor.
Absolutely, it's just an advisory opinion. You have the right to appeal to Superior Court, but state law limits what the Superior Court can do. It can only overturn a final agency decision if it decides that there's utterly no rational basis for it. It doesn't actually make an independent review. The only actual independent review is only advisory.
And there is a legislative remedy, not to spoil the end of the column, but you think lawmakers could just pass a law that changes the process?
It's completely a creature of state statute. So the legislature could do what should be the case, which is that the opinion of the independent administrative law judge is the final decision within the administrative process, and then give the agency or the person being complained about access to the Superior Court on an equal basis, and allow the Superior Court full freedom to decide matters of law, while matters of fact would continue to be bound by what the administrative law judge opined.
Like I said, the column has a lot more detail
and there's
argument
lawsuits.
And there's lawsuits, and Tom Horn gets a mention. Yeah. So I encourage you to get the more reading, read more about the issue in Bob Robb's column.